We have Ms. Dow is present and Ms. Winkles is also online. We're here to review how things are going with Dr. Lundell. So I'll just hear from the parties. I saw something in the chat. I'm not sure. Don't look at that too closely. Ms. Winkles, go ahead.
Yeah, so Dr. Lundell's reached out to both of us. Everybody signed the releases of information. I believe he's meeting with Ms. Dow's client this Friday. And so he just needs, he didn't want to put the plan together before meeting them. So what we're estimating is about a week to two after that, he should have the plan that Your Honor, so that Your Honor can review it.
Okay, Ms. Dow?
And Your Honor, actually, the last information I got from my client was that they were having, he and his wife were having their meeting with Dr. Lundell today. I believe it was scheduled for the 5th. So I would think, barring any holdups in Dr. Lundell's office, 2 weeks should probably be fine. That's fine for me, Your Honor.
Okay, great. Let's go ahead and set it to that date, September 26th at 9 a.m. We'll look forward to receiving that report. Okay, it looks like we're here
Thank you, Your
for
Honor.
the final guardian ad litem report. We'll double check to see if Ms. Fellows is online. Ms. Fellows, are you on the line today? Okay, looks like she's not here. I looked in the report in the file in Odyssey and I didn't see anything.
We are so close to settlement. At this point, we are arguing over colors of shoes and bow ties and hats. So we're so close. They're just little tiny things that need to happen. We should have that done by today. We keep setting it over because frankly, we're making a lot of progress on our own.
Okay, thank you. Ms. Jocelyn?
Agreed, Your Honor.
Do the parties, what is your preference? Is your preference to leave it unset and look forward to the resolution? If there's not resolution, it could be noted up.
I think that probably works well because I think that Your Honor keeps continuing it and maybe reading it and reading it.
Yeah, I didn't read a lot today just because I just looked at the history. We've been setting it over for quite some time, but that's okay. I mean, if the party, Ms. Jocelyn, what's your take?
Yeah, I agree with Ms. Winkles and Your Honor. I think it's best that if we just take it off. Ms. Winkles and I work very well together. So if we need to set it, maybe we end up setting it on a super small issue as opposed to like a GAL issue. I think the child's already in school, which was a big thing they've agreed upon. So like she said, we're arguing over bow ties and shoes at this point.
Very small issues, but we will get there.
Okay, great. Well, let's pardon me. Let's proceed in that fashion. That we'll just leave it unset, and the parties can note it up if there's a need. It sounds like the parties are making good progress, and appreciate everybody's efforts.
Yes, thank you, Your Honor.
Thank you, Your Honor.
And thank you, counsel.
Stephen Mortensen.
No problem.
I'm here.
As well.
Okay, welcome, Mr. Mortensen. We're here to review status of the $1,300 of spousal support if that payment has been made. Ms. Bliss, do you have any information related to that?
I do, Your Honor. I did receive confirmation from my client that $1,300 was deposited and released into her account.
All right, very good. All right, thank you, Mr. Mortensen. Do you have any comments?
Just about the motion that I had filed on the 10th of last month, I believe.
Let's see. I'm looking in Odyssey. I see in August. I don't see any motions being filed. I see.
Okay, maybe
was it earlier?
It could have been earlier.
Okay, so July 27th. It looks like there was an order, or pardon me, a motion. Mr. Mortensen's motion to vacate or alternative find satisfaction judgment and attorney fees. Is that the motion you're referring to?
That is the one. Yes.
Okay. And let's see, I'm just looking to see, usually when a motion is filed, there'll be a corresponding docket notice setting it on the docket to be heard. I'm not sure if that's been done. So without that, there is that pending motion that's out there. So we probably need to set a date to have that reviewed. Ms. Bliss, did you receive a copy of that motion?
I do believe, yes, back in July I did, but as Your Honor indicated, I didn't receive a docket notice. So I, at this point, I've been waiting for it to be noted on for my client to provide a response.
Okay. All right. So, Mr. Mortensen, you know, that motion is there. It's a valid motion. It's still pending. What we need to do is get it logged on a particular docket. So usually that's done by preparing a docket notice in conjunction with the court's clerk, clerk's court, the court's clerk, and then providing Ms. Bliss a copy of that, setting it out.
Okay.
A particular time frame, and you have to take into consideration Cowlitz County Local Rule 88 that relates to time frames. So take a look at that. You can find that on our Superior Court website.
Okay.
And then that could be
Okay.
docketed, and we can address that motion.
Okay. Very good.
All right, and then let me double check with Ms. Bliss as far as the continued pay or appear monthly appearance. What is your preference?
My hope is that this last experience maybe has had Mr. Mortensen realize the severity of this. It would be my request to maybe just do one more. Obviously, we did just have him spend some time in incarceration. My hope is that he can continue to make payments as he has displayed recently. So my request would be setting one more, maybe on the 26th of this month.
September.
And then if at that point he's continued to make those payments, then we can cease moving forward with pay or appear.
Okay, all right, thank you. Mr. Mortensen, any input on that point?
No, nothing. I agree.
Okay. Well, let's do that then. We will set the pay or appear to September 26th to make sure that the payment has been received for this month. And then we'll get a docket notice, and we'll be able to understand what the time and date that we will hear Mr. Mortensen's motion.
Okay.
You're the only, sorry, Mr. Mortensen.
No, go ahead.
Okay. And Your Honor, the only remaining concern that I have is at the last hearing, Mr. Mortensen had indicated he had several checks that he was going to deliver to my office for attorney's fees and outstanding judgments and the like. And those were never delivered. I just want to make sure those weren't somehow lost in translation, or if he hasn't provided those yet.
Those will go out today, along with the another payment for the $500 judgment that was made 2 weeks ago, 3 weeks ago, whatever it was. And you should have those by the end of the week.
Again.
Okay, great. We'll next see everybody on September 26th at 9 a.m. Is representing,
Thank you, Judge.
Okay.
it looks like
Thank you, Judge.
Ms. Osborne filing a notice of appearance on August 31st, and Mr. Swenson is here representing Ms. Driver. We're here on a motion to convert into a legal separation to divorce. So with the recent addition of Ms. Bliss to the case, Mr. Swenson, what's your position as far as moving forward today?
For the record, Stephen Swenson for Tracy Driver. I believe Ms. Bliss is going to make an oral motion for a continuance, which my client is objecting to, because this is a conversion to a divorce. It's been over a year since the decree of separation was entered. This is a highly contentious and abusive relationship. My client wants to be free and clear. And I think the statute is clear. Upon a motion of either party, it shall convert to a divorce decree. And it doesn't change the subject matter of the divorce decree. It just lets my client claim that she is no longer married. So I'll let Ms. Bliss make her motion.
Okay, great. Thank you. Ms. Bliss.
And Your Honor, as you indicated, I did just enter my notice of appearance on the 31st. I was retained late last week. My assistant, by the grace of God, was able to prepare a binder for me, but absent that, I haven't been able to review the file, speak with my client in depth as to some concerns that she has. It was my request to set the matter over 2 weeks. My hope is that during that time, I could either resolve her concerns or discuss the concerns with Mr. Swenson and hopefully get an agreed order entered. I understand his client's position, but given my newly being retained, I would ask for the courtesy of a set over for at least 2 weeks, excuse me. Understanding now that judicial conference is in 2 weeks, so it would likely be 3 weeks, but that's my request today.
Thanks. All right, thank you. And then, Mr. Swenson, are there any items, notwithstanding the request for the conversion, are there any time-sensitive issues that are involved that I didn't spot?
Time sensitive in my client wanting to be divorced.
Right. Time sensitive in that if there's a request to continue the matter for 2 or 3 weeks.
So yes, I believe now I don't have a declaration entered, but my client has indicated that Miss Osborne was in a car accident this weekend. That the car is still in my client's name. My client's also on public assistance for her and her adopted or foster son. And Miss Osborne has indicated to DSHS that they're still married, trying to interfere with her receiving public benefits. So we want the divorce to make it clear to public agencies that they're no longer married and Miss Osborne's no longer supporting her. And the car accident, my client does not want to be liable with it.
Okay. All right. So notwithstanding, it sounds like, there's a motor vehicle accident, and whether we hear the matter today or whether we hear it in 3 weeks, that's not going to change the status of the marriage on the date of the accident as far as any liability concerns. So recognizing the concerns of Ms. Driver and wanting to get out of the marriage and have it done and complete, with Ms. Bliss having come in, I'll grant the motion to continue this hearing to the 26th of September. I'll just double check with the parties if the 26th at 9 a.m. will work for everybody's schedule.
That works for me.
It works for me. Any chance we can do next week, Your Honor?
I'll turn to there's a chance. I'll turn to Ms. Bliss to see what her schedule is and what her thoughts are related to that.
I'm scheduled to be in a conference with OPD and the Office of Civil Legal Aid in Tacoma next Monday and Tuesday. So that's why I was requesting 2 weeks, as I'm not actually going to be in the office next week.
Okay. All right. Thanks for exploring that. We'll leave it set for the 26th at 9 a.m. Representing
Thank you, Judge.
Ms. Erica Temes, and can you help me with the pronunciation of the last name?
It's Heltimus.
Heltimus. Thank you.
You're welcome.
All right. And then we have Mr. Bigley joining us. Mr. Bigley, can you hear me?
Yes, I can.
Okay, great. Good to have everyone here. This is on for motion brought by Ms. Heltimus. One more time, Mr. Ball. Heltimus. Emphasis on the HEL. Thank you. Her motion related to the child's enrollment in school. So I've read this is brought on today's docket on a motion to shorten time, which was granted. So I've read Mr. Ball's pleadings or Ms. Heltimus's pleadings related to her position. I haven't heard anything yet from Mr. Bigley, likely because of the order to shorten time. So maybe I could hear from Mr. Ball, hear your client's position, then hear from Mr. Bigley to hear his position.
Thank you, Your Honor. We did file this back on August 17th and filed another order to shorten time, but it got lost. And so this is, I think we would just filed it. Normally we would be on today's docket anyway, but anyway. So our motion is to have the child enrolled in North Lake Elementary School because there's a couple reasons. Miss Heltimus lives in Longview. Her other son, who is a year or two older, was attending Castle Rock last year and can no longer attend that school. So he's going back to North Lake, and he's started school. So we'd like to have permission to enroll the child as soon as possible, preferably today, because North Lake started on August 29th. So Peyton went to Castle Rock last year. Before that, she did go to North Lake for kindergarten and first grade. Appears that, North Lake might be, there's some better things about North Lake that she has familiarity with it. She has a counselor there that she's worked with in the past. It's a smaller class size. And her brother's going to be going to the same school, and that has some benefits, just being able to go to the same school as a sibling that she lives to have time with. But also for Ms. Heltemus, it puts kind of a logistical problem there if she's going, she has two kids, I guess about 20 minutes apart in elementary school. So she'd like to avoid that. But it's just returning to the status quo. Both children or Peyton, Ms. Heltemus obtained a transfer approval for the child, the daughter, to go to North Lake. And so she's ready to go there. The school hasn't started yet in Castle Rock. We did submit just some materials on, which is the better school, but I think it's pretty close, except for I think the class size is smaller at North Lake, which has some benefits there. So yeah, we just really need to get this done, Your Honor. Sorry we didn't get it to you sooner. I'm also feel bad for the child having in this situation, and not knowing where you're going to go, where she's going to go to school. So apologize for having to put that in front of the court, but we really need to have this done, and the parents aren't able to agree. So thank you, Your Honor.
All right, thank you, Mr. Ball. All right, Mr. Bigley, what's your input, please?
Good morning, Your Honor. Just wanted to start off by, if you look at Exhibit 4, Tate was actually kicked out of Castle Rock for classroom sizes and also for discipline issues. So that's why he got kicked out. Nor me, nor does Erica also live in the school district of North Lake Elementary School. In the beginning of our battle here, Peyton was actually transferred to Castle Rock Elementary School due to being bullied at North Lake by multiple kids. She had 22 absences at North Lake in one year, and she had 2 ever in Castle Rock Elementary School, and that was actually excused absences for cheerleading due to us being in Florida. She's already missed 5 days of school at North Lake. School don't start till Thursday for Castle Rock. We have conferences actually today at 1:00 for Peyton to go here. That's all I really have to say is, Peyton was the #1 student in Castle Rock Elementary School for her grade. She succeeded so well in Castle Rock compared to North Lake, and you can see that through grades. They have this program inside her school. She was the #1 kid inside that at Castle Rock. And she also has all of her best friends here in Castle Rock as well as North Lake. So I hope you take that for what it is. Peyton is doing very good in Castle Rock. I would hate to see her to go back to a school where she's getting bullied and actually can't show up to school. I also had a foster child here that was going to Castle Rock, and I was transporting to Castle Rock and North Lake. So I don't think that that's really an excuse for, a 20-minute drive to have a kid going to different schools. This is for what's in the best of the kids' interest, not really ours. And I think what's in the best of the kids' interest to go to Castle Rock Elementary School to continue her succeeding in that academic program.
Thank you, Mr. Bigley. Mr. Bigley, can I ask, you mentioned when you had your foster child that you were the one child went to Castle Rock, the other child went to North Lake. Tell me logistically how that worked.
We took our child to Castle Rock, and then we literally we could make it in time to be able to make it to North Lake to drop off Peyton as well.
So give me some time frames. Give me some, time markers of what, you leave house at what time and drop off what time, then head to North Lake and reach there.
So we had to drop off Jackson at Castle Rock at 8:00. They started 8:00, and North Lake starts at 8:30. So we would just go straight from there, catch the freeway, and we were literally there with 15 minutes to spare to get Peyton to school as well. I mean, I know it's kind of a time crunch in a way, and I understand that 100%. But I'm willing to help as much as I can to be able to get Peyton to go to Castle Rock, whether that's, me meet her at somewhere every morning to take Peyton to Castle Rock. I just want to see our child succeed in this school. That's my main thing.
What's your understanding as far as the source of the bullying at North Lake?
She went home, I think, probably 6 times crying from school. She was bullied from multiple kids. She was shoved on the ground by kids at the playground. There was just a lot of going on about the bullying and stuff like that. And Erica even knows about that. So I don't know really why we'd want to put our kid back in that situation of being bullied.
What year was that? Was that in the 2020, 21 or 21, 22 school year?
I think that was the 21-20. That was the 21 school year. She was in first grade. I mean, she was getting like balls thrown at her face. Kids were just coming up and throwing balls at her face. And she came home with like a black eye one day. And just, it was just stuff like that that really, you know, hasn't happened at this school. I know they claim that they're bigger classroom sizes and stuff like that, but you know, that's not really what's happening.
What interventions did the school enact in response to the bullying?
We had Peyton actually in counseling for it.
Okay, what did the school do?
The school really did nothing. And I went to the principal about it and everything else like that. And I mean, she said that she got to talk to the counselor one time about it, and I don't think nothing really happened. For most of the cases, I know one of the cases, the kid and the kid's parents ended up getting to come into the school and they had a big meeting about it. But other than that, I mean, it was still continuing to happen. So.
Okay. All right. Thank you. Mr. Ball?
Thank you. So the older child, Tate, did not get kicked out of Castle Rock, and there was really no other information about the disciplinary. You know, he didn't have any disciplinary problems at Castle Rock. I know that's not about him, but there's nothing on the record that he got kicked, quote unquote, kicked out. It did have to do with the class size. Mr. Bigley didn't provide any information about what he's talking about the bullying and the absences and things like that. But we did provide a letter from the school counselor saying that Peyton and her brother Tate always come to school well dressed, happy, clean, and ready to learn before the custody case started. So that's by Daniel Goes, which was her counsel. I believe that's her counselor at the North Lake. And you know, Mr. Bigley did point out something that he's a we, you know, he and his wife kind of take on the duties, it sounds like, of getting the children to school. So Miss Heltbus isn't I. She's doing this by herself, and so if you have maybe 2 people to do that, it might be easier if maybe one's staying at home working or something like that. That might be a different situation for him, but she doesn't have that same ability. And last year, I mentioned again, she took her older son out of North Lake and enrolled him into Castle Rock, you know, to be with so they could go to the same school, and he can't go there anymore. And also it was easier for her to just, you know, to pick him up at the same time and drop him off at the same time when that was able. So like I said, Mr. Bigley didn't provide any information about the alleged bullying. I've been on this case for quite some time, and I don't see anything that there's in the record about that. There was a GAL report. I don't recall seeing anything in the GAL report about bullying being the reason to change the school. But, you know, I think that's part of the record. So those are the kind of the responses that I have.
Okay. Thank you. Let me just touch base with Mr. Bigley. Mr. Bigley, I was looking at some of these reports from North Lake School related to Peyton's performance in 21 to 22. It sounds like she did pretty well. And I'm just curious if you've looked over those and if there's any indication within those reports related to bullying or any other concerns. We argued about this before Mr. Ball came on the record about Peyton being bullied. That's when I had Brian Hunter actually as a lawyer as well. I don't know how long ago that was. I know it was quite some time ago. This has been going on forever.
It seems like. So, I mean, I know one of the years, I don't know, remember which one, if it was kindergarten or first grade, but it is drastically down compared to Castle Rock Elementary School.
It's drastically down, did you say?
Yeah, like she didn't do as well in school.
Oh, okay. And it looks like you were served with copies of school reports from 2021-22 related to Peyton's performance at North Lake.
Yeah, I've been working out of town. I haven't really had time to go over those, but I've had, when I got her report cards, I've always looked at them. So
Sure. Right. Yeah, because when I'm looking over those, I'm looking for any hints as far as, bullying or concerns related to that.
Well, they're not going to show on the report card about bullying. And this was that Erica knows about the bullying. Erica was concerned about the bullying. Back before Mr. Ball was here, we've even submitted texts between me and Erica about the bullying.
Okay. And Mr. Bigley, what's your take as far as a sibling relationship and its impact by either attending the same school or different schools?
Well, I mean, if you go back and look at the exhibit exhibit 4 of why Tate got kicked out of, it says, due to large classroom sizes in 4th grade and discipline issues, we're not going to renew his choice. So right there, I mean, I don't know if that means anything to you about that he had discipline problems in that school. If he has discipline problems in that school, I mean, I would rather Peyton not be in that school with him. I understand they do have a great relationship. I never would want to take that relationship away from them. But I feel like that this is what's in the best interest of Erica, not what's in the best interest of our child at this point, because she have only submitted a couple text messages. I didn't really have time due to me working out of the state, actually. I didn't have time to submit all of the text messages that were sent between me and Erica. She just submits what she wants you to hear, I guess, and see.
Okay, so you mentioned exhibit 4. Is that what you mentioned?
Yep, from Castle Rock School District.
Okay, I remember seeing that, so I'm just looking for it now. Just a moment.
It's just the letter. It's a memorandum dated May 18th.
Is that
saying that the boundary exception's been revoked?
Yeah.
And it doesn't say what the disciplinary issues are. It does also cite the large classroom sizes, but Ms. Healthmiss, she doesn't know what the disciplinary issues are. She talked to the school to see if they would allow him back in or allow him to go to school there again. She tried and then was denied, but no information we given to her about the disciplinary school. So it's not very fair to speculate that there were significant disciplinary issues or that they would somehow affect her sister at the other school.
Okay, so this memorandum from May 18th of 2023 from the Castle Rock School District. This is related to it was Tate's issues related to discipline and the classroom size. Okay, so Peyton didn't have any issues, any disciplinary issues while she was enrolled in Castle Rock?
No.
Okay, all right, that's helpful.
I mean, I don't think she's had any disciplinary issues.
Yeah. Okay, I just had to clarify that because I got a little confused. I thought she was having the issue, but it's clearly Tate. Okay.
Yeah, because Ms. Healthmiss doesn't live in the Castle Rock School District, so that's right.
She doesn't live in the North Lake School District either.
Yeah, I was just going to follow up with you on that, Mr. Bigley. As far as like her home, it corresponds with which school?
Well, I don't know what school is in her district at all. I know that my school district is Castle Rock School District, and she's enrolled in Castle Rock School District right now. She's able to start Thursday.
Right. I thought you said earlier that where mother lives, that North Lake doesn't even pertain to where she lives.
No, she has to get a boundary exception for North Lake. That's not even her boundary lines.
Which school district?
I think it's Mint Valley.
Okay. All right, and Mr. Ball, is it your understanding that Ms. Heltemus lives within the Longview School District?
Yeah, exactly. She does. And I mean, she lives in Longview, and it's in the record itself. So submitted a transfer request. So it's not a boundary exception request. She's, I don't know if, there's it might be many schools in Longview that she could go to, and this is the school that she chose. So.
Okay.
I've lived here all my life, and it's Mint Valley School District. I actually used to live right there.
Part of the record.
So.
Yeah. My understanding is that if you live in one school district, you can ask for permission to get a boundary exception to attend a different school district. When it's intra or within the same school district, they do have particular boundaries that I don't know if there's boundary exceptions per se, if that's what they call them, but there would have to be some coordination, I assume, with the school district itself.
But I don't see what difference it makes. Mr. Bigley's not saying that Peyton should go to the other school in Longview. He's saying that she should go to Castle Rock. So, I mean, not objecting to the others. He just doesn't want her to go to the Castle Rock or the non-Castle Rock school.
Last question.
No, never said that.
Last question I have for both parties is Castle Rock start time and North Lake start time. Are they still the 8 and 8:30?
Yes, I'm pretty sure they are.
Mr. Ball, do you know?
I have to look at my materials.
I believe it's 8:35 at North Lake and 8:10 at Castle Rock. I'm not really sure, but there's also the pickup drop-off lines we have to take into consideration that could take a lengthy time off and on drop-offs and pickups. So we really have to take that into consideration as well. That could add 10, 15 minutes. So just want to throw that in there.
8 o'clock start time for Castle Rock.
Okay. All right. And then Peyton is 7 or 8?
He's going into 3rd grade.
8 years old.
And then Tate is a year older at age 9.
Yeah.
Okay. All right. All right. I'll just ask Mr. Bigley, do you have any additional input?
No.
Okay. All right. Well, the situation is that both parties are 50-50 custodians. The parenting plan says they share joint decision-making as related to education and school. And, the North Lake had been the school in which Peyton had attended in kindergarten and also 1st grade, and then last year attended in Castle Rock. And that Tate also attended in Castle Rock. It sounded like that was mother's intention to keep the kids together for a variety of reasons, and that there's notification from the Castle Rock School District that Tate would not be able to attend Castle Rock because of the boundary, large class sizes and some disciplinary issues. And it specifically cited a policy that allows on class size to disallow boundary exceptions. So here it's a pretty even, it's kind of an even case for the most part, which kind of mirrors the 50-50 even parenting plan. I think what sways me are, one, I think the logistics are doable for either parent. I don't see anything that's preventing either party from accommodating the needs of their kids. It sounds like both are willing to do that. Doesn't surprise me. Both sound like good parents. Friendships, I assume that Peyton has friendships at both locations, having attended North Lake before and having attended Castle Rock. I think the kind of the main issue that really kind of pushes me over the edge to allow Peyton to attend North Lake Elementary is the sibling. That sense of family cohesion. You know, in one home, you have two different schools, and yet they're within a year of each other. I think because of that, there has been continuity at North Lake in the past that I'll allow Peyton, and I'll grant the motion to allow Peyton to attend North Lake Elementary.
Your Honor, I did submit a proposed order.
Yeah.
I think I have documents here, so let me just find that proposed order. All right, I will sign off on that order. I have it here, and then we'll get that filed and submitted to the court clerk. Okay, anything else? I think that addresses the issue that was at hand.
Okay, thank you, Your Honor.
Okay. Hearing nothing further, I'll go ahead and sign off on Agavino, who's the moving party today. And then Ms. Winkles, I see that your camera's turned on.
Yes, Your Honor. I just came on today. We're sending a notice of appearance in probably this morning.
Okay.
So I met with my client last week, I believe on Thursday, Friday, and she did retain me. So I'm here today.
Okay. And this relates to Mr. Agavino's motion for expanded visitation time. So we've heard from Ms. Winkles what her request is, that she's coming on to the case, having met with her client, you said last week, I think.
Yeah.
And then Mr. Robert, are you making a motion to continue, Ms. Winkles?
I am, Your Honor. I'm asking for 2 weeks just so I can respond to the pleadings. I think given where the case is right now, my client should have the ability to respond. Obviously, hiring a family law attorney in this area is very, very difficult, especially with limited income. So I'd ask that, Your Honor, let me have 2 weeks. I can get something out at that point. I would only ask for 1, but I have a trial next week. So that's why I'm asking for 2.
Okay, Mr. Roberts.
Your Honor, I understand Ms. Winkles coming in, and I've been in that position. However, given the circumstances, I do have to object. Maybe there's a workaround we can do here. The current temporary parenting plan was filed last July and was drafted by mother. The GAL was appointed, and my client's been limited to supervised video visits since he's living in California. Due to living in California, they have different interactions with the courts and the medical community. So the pool of doctors to choose from is much different, and it was really hard for him to get on a list, and there was a long delay. This is a longer than normal delay from a parenting plan being ordered to have an evaluation, and that's coming back to court when the evaluation is completed. So he did complete the evaluation. They provided collateral information. The court has all the evaluations under seal. The GAL's recommendations are what my client is asking for. Mother had the evaluations on June 7th when she still had counsel, knowing this was coming. We served these pleadings on Ms. Bliss, her prior attorney, prior to her withdrawal on August 8th. And it's not Ms. Winkles' problem, but we've done everything we could with the limitations that are built into the reality of living in California, move things as quickly as possible. The supervisor wants visits to start. The evaluation is done. Everything's been done on my client's behalf. My initial reaction is to simply order visitation. If there's problems, Ms. Winkles can certainly file a responsive or a supplementary motion to cancel. However, if the court might think it's appropriate to have court date set with the visitation already set. That's my concern is if Ms. Winkles has two weeks to respond, we're going to come back to court in 3 weeks, and that is going to effectively delay any potential visitation with my client for another month. So perhaps we can allow my client to buy a plane ticket, because I don't see how his request is controversial. It is precisely what was contemplated in the last parenting plan from over a year ago, and it is exactly what the GAL recommended once he's at the stage. So I'm a little confused about what the response could be, but obviously I'm not inside Ms. Winkle's head and I'm not going to presume, but I have a hard time believing that the GAL recommendations are going to be thrown out because he's complied with the recommendations. My concern and my client's concern is getting visitation as soon as possible. So perhaps the court would be okay if he had a visitation scheduled, we had it locked in, penciled in, and have a hearing before then. My client can buy perhaps refundable or transferable tickets. And if Ms. Winkles can disabuse the court of the idea that the visitation should go forward, then we can reschedule the visits or take some action from there. My concern is that if we come back, we're not going to have a plane ticket bought until late September, early October. There's been delay concerns in this case, as the court is aware from our declaration. There was a visit on June 28th where Ms. Ouellette the same day said she can't make it because she has a new job. That's in violation of the parenting plan. She obviously knew she had work well before then. My client did not pursue contempt because he just wants time with his kids. But the concerns of delay when there really isn't a basis to do so are present. And we just want the visitation to start as soon as possible.
Your Honor, if I could-
So Mr. Roberts, when you're proposing scheduling or penciling in a date, your client had mentioned the second, I think it's the second week of each month, the Wednesday, Thursday slots. So your penciling would be in October, would it not, the 11th and 12th?
I'm only putting this out there because Ms. Winkles is showing up, so I haven't had time to really process with my client. What we were going to ask for is next week. But that if the court's going to allow Ms. Winkles to respond, it's impossible. If we could pencil in, if it works with my client, I know his work schedule has some complications, but if we're going to come back on 26th, for example, if we could potentially have 27th and 28th, if it doesn't work with my client, then obviously we would just suspend that until the 11th or 12th. But I'm trying to get a September visit if that's possible.
Okay.
Your Honor, may I briefly respond? Again, it kind of blindsided here. Came onto the case, I want to say Thursday or Friday. I had trials last week, so really, I don't know the days. But in any event, I did read some of the pleadings here. I think this case warrants the additional 2 weeks. It sounds like, and if I got this correct, or if I don't have it correct, let me know. It sounds like there was significant domestic violence in the marriage. It was a very short-term marriage. Father was arrested, was convicted, and was arrested again for a violation of probation order for stalking. Father still is sending abusive texts, has not gone through any domestic violence treatment. This is a man with a conviction. In the state of Washington, had he done an evaluation, he would have had a mandatory 12-month treatment for DV because he has an assault DV charge and conviction. My concern is that he did it in California. He did it in California by a licensed family therapist who is not an evaluator of domestic violence, has no domestic violence acronyms after her name. Without looking at the case, aside from just a cursory glance, that's concerning. In Washington state, you would have gotten the 12-month minimum DV treatment. This is a man who has been through absolutely no treatment whatsoever, yet suddenly and has essentially abandoned the children for a period of time, not utilizing all of his visits, coming in and out. Children haven't seen him in forever. And now he's pushing, and he's pushing very hard. And really, what do they say? Horses don't change into zebras, and without some paint or something like that. The fact is that something has to happen. There has to be an intervening change to really make somebody that much different. It's concerning that they don't give her the opportunity of having counsel that would be fully read, and I could come back and a week I can make happen. I mean, I have a trial next week, but really she does get the opportunity to respond. And it's difficult to respond. She is the victim of domestic violence. It's difficult for her. She is, on state medical, and there are additional issues. She's supporting the children. The fact is there are too many complicated, complex issues here, such as what sort of evaluation was asked for and what actually was given. Has dad done everything the GAL has asked? And there are these concerns for the children as well. The children have had one counseling session, if I remember correctly, with either Community House or Core Health. have had no additional ones. That's a problem. Nobody set these children up for an in-person visit. There's not really been any reunification counseling or therapy or meetings. Just going from one thing to another, especially after not seeing this man for a very long time, is going to be really traumatic. And nobody knows what those children witnessed other than the children. To throw them back, it would be dangerous. I'm only asking for 2 weeks. I can speak to Olivia Lovely. I can speak to whoever needs to in that, whoever we need to in that 2 weeks to get a game plan forward. We're not saying it's a hard no on my client's side. She just needs some time to respond. This is a man that's waited a long time on his own accord to not see his kids. He can wait another 2 weeks. It really won't kill him. My concern is penciling these dates in. It's like building the house on over a boundary line. Well, you've already built it. So is it going to stay? Well, more likely than not, it probably will. That is my concern. It's essentially bullying the court into action because I've already spent all this money. So I ask Your Honor that we just hold the status quo. I'll pump this thing out if we could even have a week. If it's, I mean, I prefer, I guess the 19th is judicial conference. I prefer the 26th. I do have a trial next week, but she needs to have a proper answer put out. Thank you.
All right, so go ahead.
I'm sorry, Your Honor. There was a lot there, and I have to object to some of it. My client was not convicted of assault. It was DV harassment, which is what it is, but it was not assault. So the representations about what treatment he would have to do, I don't believe that's accurate. Also, much of information she states is what the GAL processed. It's already been litigated. Mother had an attorney a year ago, and a motion was heard on, and mother's concerns were granted. We're not here to relitigate what happened 5 years ago, which was already litigated in 2022. Concerns were addressed by the court. Mother trusted the parenting plan. It was signed by the court. The GAL was appointed. She gave the GAL all the information that she had and wanted, and the GAL made these recommendations, knowing the distance, the time distance between father's last visit, knowing the history. So this isn't new to the court. This isn't like the court needs to be briefed on something that hasn't happened before. The court's already litigated this. It would be inappropriate for the court to reconsider something that it already made a ruling on a year ago. The GAL already considered, already made recommendations. So Ms. Ouellette had an opportunity to talk to this doctor and give her the information, and the doctor reviewed extensive information. There was never a question. There's never an objection made to the evaluation when we sent it 2 months ago. And when she had counsel for over a month after receiving it. So I certainly would submit to the court as how you ever want to deal with it, Your Honor. I understand there's complications here, but it's not accurate. This is some new information the court needs to process.
Okay, thanks. All right, so we're basically here talking about the motion to continue the motion hearing. The pending motion, it looks like it was mailed on August 8th, and Ms. Bliss withdrew effective on August 9th. And I'll note that the notice was mailed, and so obviously it didn't get there on the 9th. It was probably sometime after.
Sorry to interrupt your. I'm sorry to interrupt, Your Honor. It was emailed, and there was a slash in the declaration of service. It was emailed. I can send the court that right now. Ms. Bliss confirmed receipt of it prior to withdrawal. I apologize for any confusion, and I didn't mean to interrupt, but it was served on time.
Well, I'm not saying that it wasn't served on time. Even if that's accurate with the being served via email, it gives all of it a day to respond, and the attorney's leaving on that date. And so I think that warrants. I think that's important to recognize the fact that this motion was brought and it was mailed the day before the effective date of the withdrawal. And now Ms. Winkles is here. Her client wants to respond. The parenting plan of 2022 July talks about the need for SUD evaluations, DV evaluation, limitations under 191 for neglect and SUD. She might want to have something to say about that. So I'll grant the motion to continue. We'll set that to September 26th at 9 a.m. We can't do it on the 19th, but we can do it on the 26th at 9 a.m. So I'll double check with Mr. Roberts if your schedule allows for that.
26th, I can do that.
Okay, and Ms. Winkles, that works for you?
Yes, that works for me.
All right, we will come back on September 26th at 9 a.m. and hear the motion brought by Mr. Agapino.
Thank you.
And just thank you, Your Honor. And just so I can have an understanding of when to expect documentation, when any response would be filed, could we get clarity on that, please?
I can probably have it to you. See, today's Tuesday. Like I said, I do have a trial next week. If I can get it to you by the 14th, if that would be okay. And that would give you, obviously, you'd want to get it in before, you'd want to get it in by the 22nd, really. So they would have the paper copies and the.
If you, I wouldn't have an issue with that. If you need
Okay.
to the 14th, that's fine. I can probably have something for the 22nd, but if that works for Your Honor, I would be fine with that.
I would default to the court rules. However, the parties want to work that. If you agree to something else, that's fine. Otherwise, court rules apply.
All right. Thank you, Your Honor.
Thank you both.
Great. That'll conclude today's hearing on that matter. And then I think that concludes all the matters that were docketed for today.